Stop what you are doing right now because a Supreme Court ruling came down that could take away your gun rights, and you might not even know it yet. The highest court in the country just voted 8-1 on a decision that affects almost every gun owner in America, and the government is not telling you about it because they are counting on you never checking. If you carry a gun, if you own a gun, if you have ever been in a fight with someone you live with, or if you simply have a friend or family member who owns a firearm, you need to hear every word of this video before tomorrow. The rule that just got confirmed can send you to federal prison for 10 years. It can cost you $250,000. And the worst part is that you might already be on the list that triggers it without even knowing it. I am going to walk you through exactly what the Supreme Court decided on June 21st of 2024. I am going to show you the single action that takes you 5 minutes and tells you if you are about to lose your rights. And then I will give you the 5 steps you must take today so that you are not the next gun owner sitting in a federal courtroom wondering how this happened. This is not theory. This is real law. This is real risk. And if you carry, this could be the most important 5 minutes of your year. Let me explain what just happened because most news outlets buried the lead. On June 21st, 2024, the Supreme Court announced its decision in a case called United States versus Rahimi. The vote was 8-1. Chief Justice John Roberts wrote the majority opinion. Justice Thomas was the only one who disagreed. The case was about a man named Zaki Rahimi who was subject to a domestic violence restraining order. He was caught with a gun. He said the law that banned him from having a gun while the order was active was unconstitutional. He said it violated his Second Amendment right under a previous Supreme Court ruling called Bruin from 2022. The Supreme Court said no. The law stayed on the books. 8 justices said the federal government can still take away your gun rights if a court has ordered you to stay away from someone. This is the rule. It is real. It is in effect right now. And it applies to you the moment a qualifying restraining order is signed against you. Even if you never went to jail, even if you never touched a gun, even if the order feels unfair to you. Here is the rule in plain words so you can understand it without a lawyer. The federal government passed a law years ago called Section 922G8. You do not need to memorize that number. You just need to know what it does. It says that any person who is subject to a court order that tells them to stay away from an intimate partner, and that order was issued after a hearing where they had a chance to show up and speak, cannot legally possess a firearm, not a pistol, not a rifle, not a single round of ammunition, none of it. And if they are caught with even one gun while that order is active, they can be charged with a federal felony. That felony can put them in prison for up to 10 years. It can fine them up to $250,000. And after they serve their time, they lose their Second Amendment rights forever. That is the trap. That is the rule the Supreme Court just confirmed. And that is why I am talking to you right now. Now, let me tell you the single action that you must take today. It takes 5 minutes. It costs nothing. And it tells you without a doubt whether you or anyone in your household is about to lose their gun rights. The action is this. Search your full legal name in your county court records right now. Every county in America has a public database online. You pull up the website, you type your name, you look at every case listed under it. If you see anything that says protective order, restraining order, order of protection, stay away order, or no contact order, you need to pause this video and read every word of that order. That is the check. That is the action. That is the same action I want you to tell every gun owner you love to do tonight. Search your name in court records today. I will say it again because it matters. Search your name in court records today. And I will say it one more time at the end. Search your name in court records today. If you do nothing else from this video, do that one thing. Let me walk you through the 5 steps every gun owner must take after the Rahimi ruling. These are the steps in order. Take them one at a time. Do not skip ahead. Step 1. Search your full legal name in your county court records right now. Use the official county website if you have one. If your county does not have an online system, call the clerk of court and ask them to search your name. Tell them you want to know if there is any active order against you. Step 2. If you find an order, pull the full case file. Read every line. You are looking for 2 things. First, does the order say you must stay away from a current or former intimate partner? Second, did the order come after a hearing where you had the chance to be there? If both of those things are true, you are subject to Section 922G8 and you cannot legally possess a firearm right now. Step 3. If you are subject to an order, remove every firearm from your home today. Do not give them to a friend. Do not lock them in a closet. Remove them. Give them to a family member who lives in a different house. Have them stored at a licensed gun store. Get a written receipt for every firearm. Step 4. Hire a firearms attorney in your state. This is not a place for a general lawyer. You need someone who handles Second Amendment cases every week. Call your state bar and ask for a referral. Ask for the first consultation to be free. Most firearms attorneys offer a free first meeting. Step 5. After the order expires or is dismissed, file a petition to restore your gun rights. The federal system has a form for this. Your state has another. Your lawyer will know which one to file. Do not skip this step. If you do not file, your rights stay gone forever, even decades later. Now let me explain why this ruling matters so much, even though almost no one is talking about it. The reason is that a restraining order does not require a conviction. You do not have to be found guilty of anything. You do not have to spend a night in jail. You do not even have to be charged with a crime. A family court judge can sign an order after a short hearing where your partner or ex-partner shows up and tells their side of the story. If the judge believes there is a risk of harm, the judge signs the order. The order can last 1 year, it can last 3 years, it can be renewed, and from the moment the judge signs it, you lose your right to possess a firearm under federal law. Most gun owners think they would know if they had a restraining order. Most gun owners are wrong. The order can be issued against you while you are at work. You can find out about it from a sheriff at your door, handing you a stack of papers you never read. The papers say you cannot contact someone. The papers say nothing about your guns. But the law says you have to figure out the gun part on your own. And that is the trap that catches tens of thousands of Americans every year. They miss the gun part. They keep their pistol in the nightstand. A cop finds it during a traffic stop, and now they are facing 10 years in federal prison. Let me also explain what the Supreme Court did not do, because this part matters too. The court did not vote to take guns away from every American. They did not vote to ban a class of firearms. They did not add new paperwork for permit holders. They voted 8-1 that one specific category of people can lose their gun rights. And that category is anyone subject to a qualifying domestic violence restraining order. So if you have never had a restraining order issued against you, this ruling does not change your rights. You can keep buying guns, you can keep carrying, you can keep doing everything you are doing today, but the moment a qualifying order is signed, your rights change instantly, and the government does not send you a letter to let you know. That is the hidden rule. That is what the system does not tell you, and that is exactly why I made this video. Now let me cover state variations, because the law changes a little depending on where you live. Federal law applies in every state. If you are subject to a qualifying restraining order, you cannot possess a gun in California, Texas, New York, Florida, or anywhere else. But some states add their own rules on top. California requires anyone subject to a domestic violence order to turn in all firearms within 48 hours. Texas requires you to file an affidavit saying you no longer possess firearms. New York has its own ban list that includes people subject to family court orders. Florida adds a 5-year waiting period after an order expires before you can buy a gun again. Illinois makes it a separate state felony to possess a gun while an order is active, on top of the federal charge. So the federal rule is the floor. Your state can add a second floor on top. That means in some states, the same set of facts could put you in violation of 2 laws at once, and you face 2 separate prosecutions. This is why your local lawyer matters. Federal law is the same everywhere. State law is different in every state. You need to know both. Now let me cover a few special situations because they come up often. First, what if the order is from years ago? If the order is expired or dismissed, you are clear under federal law, but some states still bar you. Check your state. Second, what if you did not know about the order? Ignorance is not a defense. The Supreme Court confirmed this in Rahimi. If the order was properly served, your knowledge of it is irrelevant. Third, what if the order was dropped? Once it is dropped, you can petition to restore your rights. Do that immediately. Fourth, what if you are married and one spouse files an order against the other? From the moment the order is signed, the spouse subject to it loses gun rights. Even if the couple later reconciles, the order still has legal force until it is formally dismissed. Fifth, what if you live with someone who has an order? The rule is about possession, not about living with someone. But if a gun is in a shared home and the person subject to the order can access it, that is a problem. Move the guns out of the shared home. Here is what happens if you do not act. Let me be very plain. If a restraining order is filed against you and you do not search your name, you do not read the order, and you keep your gun at home, you are now living with a federal felony. The first time a police officer runs your name during a traffic stop, a background check, or a domestic call, the order will show up. If the officer searches your car or your home and finds a gun, you go to jail. You will be charged under Section 922G8. You will face a mandatory minimum. The prosecutor will tell the judge you knew or should have known. The judge will not have mercy. Your wife will not be able to bail you out with the house. Your kids will not be able to visit you in prison. You will lose your job. You will lose your right to vote in some states, and you will lose your Second Amendment rights for life. That is the price of 5 minutes you did not spend searching your name. That is how serious this is. Let me close by telling you the one thing I want you to remember from this entire video. The one thing is the action. Search your name in your county court records today. That is it. That is the only thing you must do. Everything else I told you was the explanation. The court ruling, the 8-1 vote, the federal felony, the 10-year prison sentence, the $250,000 fine, all of that was context. The action is the search, so do it now. Pull out your phone, open your county court website, type your name, look at every case. If you see anything that says order, protective order, restraining order, or stay away, you have work to do. If you see nothing, you can breathe. But do not leave it to chance. The government is not going to send you a letter. The police are not going to flag your account. The only person who can protect your rights is you. And the only way to do that is to check. Now, let me make sure you understand what to share, what to subscribe for, and what to do right now. Please listen to these 4 important things before you close this video. First, send this video to one person you love who owns a gun. It could be your brother. It could be your father. It could be your best friend from the range. Send it to them tonight. One share could protect them from a 10-year prison sentence they do not even know is coming. Most people never learn about this rule until they are sitting in a courtroom. You just learned it. Make sure the people you love learn it too. Second, if you are not subscribed to this channel, do it right now and hit the bell. Supreme Court decisions like this one change every single year. When they change, I will be here to break down exactly what the change means for your rights, your money, and your safety. That is what this channel is for. That is what I do every week. Third, go check your court records tonight. Pull up your county website. Type your name. Make sure no order is sitting there that you forgot about. If you carry a gun, this is not optional. This is the new normal. Fourth, remember that the government hopes you never learn these rules. They hope you stay quiet. They hope you never search your name. They hope you keep your gun in the nightstand until the day a sheriff knocks on your door. The more people who know this rule, the more people stay free. Share this video, tell your family, tell the people you shoot with, tell your coworkers who own guns. Every share is one more person who will not lose their rights by accident. That is how we beat this, one share at a time. And the one thing to remember from this entire video, search your name in your county court records today. Say it with me. Search your name in your county court records today. Say it again. Search your name in your county court records today. That is how you protect yourself. That is how you keep your rights. Knowledge is your best protection, and now you have it.